Welcome to the Explaining Family Law podcast with me, Tim Whitney.
And me, Jen Curtis, from Mills and Reeve. In this podcast, we break down family law issues and answer the questions that people find themselves asking during some of life's most challenging moments.
In this podcast, we're going to talk about wills and divorce. I'm joined by Abbie Green, an associate in our Leeds office who spent time in both our family and private client teams. Welcome, Abbie.
Hi, Tim.
So let's start with the main question. Can you change your will as soon as you separate? Or do you have to wait until you're fully divorced?
Yes, you can review your will straight away and amend it on separation. You don't have to wait for your divorce to be finalised. We would actually advise you to review the terms of your will as soon as you can on separation, as your will may no longer reflect your wishes and how you want your estate to be split up. So if your finances are still up in the air and you're not sure which assets you'll retain on divorce, we would recommend that you put a short-term fix in place to make it codicil. And this document is something that would amend the terms of your existing will. And then you can wait for the financial picture to be finalised later on before you make the more extensive review of your will later on.
Great, thank you. And so what would happen if a client didn't change their will?
So if you didn't change it, your current will would remain valid during the time of your separation. That would mean that your ex-spouse could still inherit or could act as executor or maybe even as a trustee, depending on the terms of your current will. There would be a real risk that your estate would pass in the way that no longer reflects the intentions that you have on separation. So your spouse could benefit or could have very high levels of your control over your estate until the divorce is finalised.
And then, I suppose, thinking ahead slightly, so once a couple have their final order in their divorce, does that have any impact on wills?
Yes, it does. So once the divorce is completely finalised, the law basically essentially treats your former spouse as though they died before you for the purposes of your will. So in this case, gifts that would be made to them would fail, or they'd be removed from roles that they have in their will, such as executor or trustee. So it would stop them benefiting. However, it could lead to other problems in your will, such as create gaps or unintended outcomes that wouldn't be ideal in purposes. So, for example, if you left your whole estate to your ex-spouse, which is quite common in practice, this would mean that your estate would actually fall under the rules of intestacy, which basically would to the effect that you almost didn't have a will in the first place. And that would lead to strict rules being in place for who would inherit. And there's also another outcome that would mean that certain mechanisms that your will could utilise, such as trust structures, the structure would no longer work as intended. For example, if your ex-spouse was listed as a trustee that creates a trust under your will for the benefit of your children, for example, this could have unintended outcomes, meaning that the trust structure wouldn't be as effective as originally hoped.
That's great. So it sounds like it's another time to review your will and make a new will.
Yeah, definitely.
And we've covered the rules of intestacy on a previous podcast, which we can link below in the comments. So just thinking about once a couple are divorced, is there anything they need to think about when it comes to the contents of their will, or can they put whatever they want in there?
So broadly, you're free to leave your estate however you choose to in your will. But there is a caveat that certain people, such as children or dependents that you may have, can bring claims against your estate if they feel they haven't been reasonably provided for. So we would always recommend that if you were making decisions that weren't completely obvious or kind of unequal shares that wouldn't be necessarily immediately assumed, then we would want this to be clearly evidenced and your reasoning behind any decision to be evidenced in your letter of wishes. And this would be used to avoid any challenges or disputes to your estate at later court for that.
From the divorce side, if there's a financial order in place, it would be worth clients sharing that with their private client lawyer so that they can make sure that there is some consistency between what the order had said they should pay and the terms of their will. Brilliant, that's great, Abbie. And then I suppose just whilst we're on the topic, are there any other related points that people should think about?
Definitely. I think it's such an important topic that really has major impacts in your life and in your death, and depending on who would inherit your estate. So, but to keep things short for this podcast, there's just a couple of things that I'd want to keep in mind. One of the most important ones would be to ensure that any lasting powers of attorney that are being set up would be updated alongside your will. This is to make sure that your ex-spouse isn't included in there, make sure that everything's consistent. Another thing that I would advise is to double check your things like your pensions or your life insurance nominations, as these often sit outside of the will structure, so would need to be changed separately to ensure that no one benefits that you wouldn't want them to benefit in the future. And I think one of the key things in these areas, especially in divorce and separation, is that, especially when emotions are really high, I think future estate planning is often the last thing on people's mind during an emotional separation. I would always advise people to ensure that these are being considered, as this is often a time, especially during separation, that people are most exposed to legal implications that are often unintended.
Yeah, I mean, it sounds like it's a good reminder for people to review these types of points and sort of do a housekeeping exercise to make sure that everything's still doing what they want it to.
Definitely.
So hopefully people now have a better understanding of the issues to think about and when to speak to a lawyer to either write or update their wills. We should obviously mention that we've got a brilliant private client team who'd be happy to help. Thank you very much, Abbie, for joining me and for that very clear explanation of a true topic.
Thanks very much, Tim.